Okay, I think we can get started. Thank you all for joining us. My name is Randall Abate. I'm the Assistant Dean for Environmental Law Studies at GW Law, and it's a pleasure to be a co-sponsor for this exciting event today. We're going to have some very brief opening remarks. Today's panel, Rights of Nature to Protect Animals and Environment, Ecuador as a Case Study, features three co-sponsors. So the first is the Environmental Law Program at GW Law, and we're very proud to partner again with GW Law's Animal Law Program, and you'll hear shortly from Dean Kathy Hessler, and also the Earth Law Center. You'll also hear soon from the Executive Director of the Earth Law Center, Grant Wilson. Our connections run deep with both of these co-sponsors, and we're really excited to work with them again for today's event. We, in the Environmental Law Program, regularly partner with GW's Animal Law Program on events and initiatives at the law school and across the university, and we're very excited to continue that collaboration. And we've also partnered with the Earth Law Center. We had a highly successful Earth Law Symposium here at GW Law in September of last year, and we are continuing to work with the Earth Law Center to launch a first ever Earth Law Moot Court competition in 2025. And my personal connections to Earth Law Center run deep as well, with Executive Director Grant Wilson and the moderator for today's event, Kevin Schneider, Counsel for Earth Law Center. We've worked together on many initiatives prior to my arrival at GW Law a few years ago. So we are also grateful to our distinguished panelists from Ecuador today, Judge Nuques and Hugo Echeverria, and also, of course, our moderator, Kevin Schneider. This is a continuing emphasis for us, this rights of nature in Ecuador context, and that's not a coincidence, because last but not least, I'm proud and deeply grateful for our LLM student in international environmental law in our program, Fernando Munoz, and his work in securing Judge Nuques as a speaker for this event and for providing valuable translation services for today's panel. Fernando is a lawyer from Ecuador, and we're very excited to have him this year in our program, and we'll be very sorry to see him go, but look forward to staying connected with Fernando as our link to Ecuador on these important rights of nature issues. So with that, I'll turn things over to Kathy Hessler, our Assistant Dean for Animal Law.
Thank you, Randy. It's my pleasure to work with Dean Abate and the Environmental Program at GW, and also with the Earth Law Center again. It's a wonderful opportunity to lift up the intersection between environmental and animal law, and these conversations create new opportunities and create opportunities to highlight new perspectives about how we can move forward to protect the interests of animals and the environment. We know that in the legal sphere, it's difficult to get these interests of animals included, both in legal, ethical, and social conversations, and that this is evolving work, right? The rights of nature framework is not the end of the discussion, it's sort of the beginning, and it's happening in a way that's unique and holds hope for significant change, which is wonderful. And so we're delighted to have these folks with us today. There are cases around the world that are addressing the interests of animals specifically, some in the US and some elsewhere, some within the rights of nature framework and some not. And some of these cases are positive, some go well, and some do not, right? And so this is part of the conversation. We need to look at what's working, take hope from what is, and make some adjustments. There's also a connection between the rights of nature concept and the Just One Health approach that helps people across the globe understand that working for the benefit of animals and the environment also benefits human beings, and that we should be looking for harmony across these domains. So we also know that it's really helpful to look at science, about the science of the capacities of animals and the needs of animals and nature. And so that's evolving area and helpful to our work. We understand that it makes sense to look at animals in an instrumental way, a strategic way, to try and figure out what is beneficial to species and ecosystems and humans. And then we also need to have the conversations about recognizing the intrinsic value, not just the instrumental value of the animals. And so we know that the animals are falling into a couple of different categories, and this might be helpful as we think about the conversation today. So we have animals in nature. They're living in the wild, and they have risks to themselves, to their existence and their habitats from human activity. Animals from the wild taken into human captivity, and then animals bred into captivity who are living in captivity or who are meant to be released into the wild. So those are four categories of animals for whom these rights of nature's conversation may impact differently, right? And so that's just sort of one set of paradigmatic lenses that we can use as we begin thinking about these. But that's enough for me. I'm just here to help us remember the animals specifically. I'm delighted to be a part of this and co-hosting, and I'll turn it over to our friend Grant Wilson. Thank you.
Thank you so much, Professors Abate and Hessler, for having us here today. And Professor Hessler taught me animal law about 13 years ago when I was a law student, so it's an extra great privilege to be here, and is calling on me today to introduce Earth Law Center rather than to answer a challenging animal law question. So I think that's a slightly less intimidating context. Thank you to George Washington Law and its animal law and environmental law programs for co-hosting this event today. And, I've seen firsthand how George Washington Law School equips its students not just with the skills and knowledge to enforce the laws as they stand, but really trains them on how to dream up a better system of justice for all life on the planet. And so it's a great honor to continue to join you in that journey. As you heard, I am Grant Wilson, the Executive Director of Earth Law Center. We are a nonprofit committing to aligning human laws with the laws of nature. And the rights of nature are certainly a focal point of our work. We also work on the rights of future generations, giving nature a voice in governance, and other legal innovations that put nature into the very core of the legal system. And we call this field Earth Law, like human rights law, but for the entire planet. At Earth Law Center, we're in the business of legal innovation and transforming the law. And as you'll hear more about, there was a time when the United States was a thought leader, a global thought leader in the space of environmental law, sort of the traditional regulatory approach. But now so many other countries have passed the United States in the field of earth law, emerging ecocentric law. And we have to look to them for inspiration, for guidance, for case law, for jurisprudence, as we consider how to evolve our own legal system in the United States and to other countries listening in on the conversation as they go through the same process for what it means to create a legal system that aligns with nature. And in Ecuador in particular, they are so far beyond just this basic idea of nature having rights and nature having standing, which is sort of where a lot of this came from. It's a profound concept, but what they're doing in Ecuador is to really look at what it means to give nature a voice, a role in law and governance in all aspects of society, and to handle complex questions such as what is the overlap of rights of nature and animal law, and how do we make this all work in practice? And it's such a great honor to hear from just that folks today who can tell you about experiences in making this all work in practice so we can all become inspired and hopefully integrate some of these learnings into our own careers and legal professions. So with that, thank you again so much for having us, and I'll turn it back over to the panel. Thank you.
Okay, thank you, Grant. So you heard I'm Kevin Schneider. I'm legal counsel with the Earth Law Center. Prior to that, for many years, I worked with the Non-Human Rights Project, which is how I came to really know about Judge Newkes's work through a particular case, the Estrellita case, which we'll be talking about, really focusing on a lot today. And in that case, just 2-3 years ago, began as a habeas corpus case. Like Professor Hessler mentioned, Kathy mentioned, that's sort of second or third category of animals taken from the wild. Estrellita was a woolly monkey who was taken from the wild at a very young age and kept as a pet, which is actually illegal in Ecuador, has been for a long time. And the authorities found out about this and seized Estrellita under, not the best circumstances. And sadly, Estrellita died in custody. But before she did, and before the owners realized that she had died, they filed a habeas corpus action trying to essentially recover Estrellita. So that gets into very obviously complicated questions, stuff that we dealt with here in the United States, the Non-Human Rights Project. And sadly, many of you may know the founder of the Non-Human Rights Project, Stephen Wise, passed away this year, which was a huge blow to the movement. But I think, you know, what we're doing today and what we're talking about and the sort of the future of these ideas is a very fitting tribute. So, you know, I'm really happy to be able to draw on that experience. So basically what happened, we heard about the Estrellita case and, you know, working in these the sort of realm of habeas corpus and rights and personhood for animals in the United States. We were obviously immediately interested in it. And along with Harvard Law School's animal law program, which is an awesome program, we wrote an amicus brief. We did a Spanish version and an English translation. And we addressed this idea of habeas, but kind of maybe more relevant today, just because it's sort of broader reaching, where the question of rights of nature and how they may apply, because the Constitution of Ecuador, the first and still only in the world to have such a constitutional rights of nature, was not clear, right? It didn't say animals also get this or wild animals also get this right. It's, you know, as a lot of constitutional provisions often are, more broad, right, and not speaking to every single detail. So very excited today to, you know, jump in to hear from Judge Núñez, who crafted that decision in Estrellita's case, and really hear more about how she and the court and thinkers in Ecuador and throughout the region, and really throughout the world, are beginning to tie these issues together. And hear from Hugo Echeverria, who's known for many years, been honored to know and as really a leading practitioner in Ecuador in really bringing these areas together, and has been for a number of years, rights of nature and the rights of animals. So Hugo will speak to some of the, you know, really important cases going on now. And I think we'll also learn a bit about how we can kind of bridge this maybe divide that exists between environmental folks and animal rights folks. It's certainly something, you know, that I've seen sort of working in both realms. And so really excited to start. And Judge Núñez will go first with the presentation, and then Hugo Echeverria will follow up, and then I have a couple questions, and then we're hoping to have time for questions at the end. So please do have those ready to go. So with no further ado, I'll hand it over to Judge Núñez, and thank you so much for everyone putting this together today.
Doctora, puede empezar.
Good morning. I would like to thank the organizers for the invitation to speak at this event. I feel very honored to participate. I would like to also thank Fernando for contacting me and for interpreting for me today. I would prefer to speak in Spanish, so my presentation is as fluent and precise as possible. Antes de comenzar esta exposición, quisiera observar un aspecto de esta sentencia que considero relevante, porque esta sentencia va a partir de un reconocimiento de que el derecho es una ciencia que está en una constante evolución y que ha tenido como uno de sus objetivos la protección de quienes ha ido considerando sujeto de derechos en el tiempo. La sentencia va a partir de considerar en el espectro tuitivo de un ordenamiento jurídico no solo aquellos que tienen capacidad civil para ejercer derechos y contraer obligaciones, sino que a través de un giro fenomenológico comprender a toda la realidad observada como una comunidad vital que está en constante interrelación y evolución, reconociendo con la calidad de sujetos de derechos no solo a personas naturales y jurídicas individualizadas, sino también a comunidades, pueblos, nacionalidades indígenas, a pueblo afroecuatoriano y montubio, a las comunas y a la naturaleza, pero a la naturaleza y también a los elementos que componen esa naturaleza.
Before starting this presentation, I would like to observe an aspect of this judgment that I consider relevant and important. This judgment starts from the recognition that the law is a science, a discipline in constant evolution, and that one of its goals, one of its objectives, is the protection of those who have been considered as subjects of rights over time. The opinion starts by including into the protective spectrum of a legal system not only those who have civil capacity to exercise rights and contract obligations, but through a phenomenological turn to understand the whole reality, observed as a vital community in constant interrelation and evolution, recognizing with the status of subject of rights, holder of rights, not only individualized natural and legal persons, but also communities, indigenous peoples, nationalities, African American people, the Montubio people, the communities, and nature. And not only nature, but also all the elements that include nature.
Así, la Constitución ecuatoriana va más allá del clásico antropocentrismo que había inspirado al derecho durante la modernidad, para acoger un sociobiocentrismo con fundamento en nuestras raíces milenarias y a los aportes del pluralismo y la interculturalidad de los distintos pueblos que conforman al Ecuador, reconociendo de esta manera la evolución del derecho y la forma como los sujetos de derecho han sido protegidos.
Thus, the Ecuadorian Constitution goes beyond the classic anthropocentrism that had inspired the law during modernity, to embrace a social biocentrism based on our millenary roots and the contributions of pluralism and interculturalism of the diverse peoples that make up the nation of Ecuador, recognizing the evolution of the law and the way in which the subjects of rights have been protected.
¿Por qué es importante tener esto presente? Porque el caso que conocerá la Corte y que vamos a ver la mañana de hoy, parte observando si un habeas corpus es una garantía adecuada para la protección de un animal como una norma chorongo que es estrellita. Y la respuesta que va a dar la Corte va a concluir que el reconocimiento de los animales como sujetos de derecho constituye la fase más reciente en el desarrollo de su protección jurídica, la cual se sustenta en el reconocimiento de aquellos como seres vivos con una valoración intrínseca que los convierte en titulares de derechos y, en consecuencia, su protección puede ser otorgada o garantizada a través de diversas garantías que pueden constar en el ordenamiento jurídico.
Now, why is this important to keep in mind? Because the case that the court will hear starts by observing whether an habeas corpus, a constitutional claim, is an adequate claim or guarantee for the protection of an animal, such as the monkey estrellita, which means a little star. And the court's answer will conclude: the recognition of animals as subjects of rights constitute the most recent phase in the development of their legal protection, which is based on the recognition of those as living beings with an intrinsic evaluation that makes them subjects of rights. Consequently, their protection can be granted and will be granted through the various guarantees or constitutional claims that the legal system has.
A continuación, voy a hacer una breve descripción del caso que entiendo que ya es conocida. La Corte Constitucional del Ecuador, mediante una sentencia de revisión, voy a dar el número por si es de interés, que es la 253-20 JH 22, reconoció a los animales como sujetos de derechos. La causa se originó en la presentación de un habeas corpus a favor de una mona chorongo denominada Estrellita, que había vivido 18 años en una vivienda humana con una mujer que se percibía como su madre. Esta situación va a ser conocida por las autoridades públicas pertinentes en Ecuador, quienes van a iniciar un procedimiento otorgando la custodia del espécimen de vida silvestre a un centro de manejo autorizado por la Autoridad Ambiental Nacional, Finalmente, el habeas corpus que pretendía la licencia de tenencia de vida salvaje y de evolución de la mona chorongo fue negado por considerar la necesidad de proteger a la naturaleza por parte de la autoridad ambiental. Pero es importante tener presente que cuando fue presentada el habeas corpus, la mona chorongo ya había muerto.
The following is a section of the case, which is already known, but it is important to highlight some of the text. The Constitutional Court of Ecuador, through a revision of the decision 253-20-JH-22, recognized animals as subjects of rights. The case originated in a constitutional claim of habeas corpus in favor of a chorongo monkey named Estrellita, Little Star, who had lived for 18 years in a human dwelling with a woman who perceived herself as the mother of the monkey. This situation will be known by the agency of the government of Ecuador, that initiated an administrative procedure granting custody of the wildlife animal to a management center authorized by the National Environmental Authority, the agency of the government. Finally, the habeas corpus seeking the license to possess the monkey, to return the monkey to the house of the mother of the monkey, was denied by the lower court. The lower court denied the habeas corpus because it deferred to the power to protect nature by the Environmental National Agency, and because it is important to highlight that when the claim was sued, the chorongo monkey Estrellita was already dead.
La Corte Constitucional, luego de haber seleccionado el caso, lo seleccionó para desarrollar jurisprudencia vinculante, va a emitir una sentencia con 3 finalidades. La primera, reconocer el alcance de los derechos de la naturaleza y determinar si ésta abarca la protección de un animal silvestre, en particular como la mona chorongo Estrellita. Segundo, revisar si en el caso concreto de la mona Estrellita se habían violado derechos de la naturaleza. Y tercero, desarrollar lineamientos generales para la procedencia de garantías constitucionales a favor de animales silvestres como la mona chorongo Estrellita.
The Constitutional Court of Ecuador, after granting certiorari for the development of binding jurisprudence, issues a judgment in order to analyze 3 things. First, recognize the scope of the rights of nature and determine whether it covers the protection of a particular wild animal, such as the monkey Estrellita. Second, review whether in the specific Estrellita monkey case, the rights of nature had been violated. And third, to develop general guidelines for the applicability of constitutional guarantees or claims in favor of wild animals, such as the Estrellita monkey.
La sentencia va a abordar interesantes aspectos. A continuación, quisiera yo destacar los que a mi criterio son los puntos más relevantes del análisis que realizó la Corte. El primer punto es los derechos de la naturaleza. La Corte va a realizar un importante recuento de los avances jurisprudenciales que había realizado en los últimos años relacionados a los derechos de la naturaleza, destacando que la naturaleza es un sujeto complejo que debe ser comprendido desde una perspectiva sistémica y que sus componentes o manifestaciones particulares pueden llegar a configurar titulares determinados de derechos, advirtiendo que la naturaleza en todos sus niveles de organización ecológica se encuentra protegida por el derecho. Y hay un segundo punto también que quisiera destacar, que es el principio de cláusula abierta. Esta sentencia va a analizar que los derechos de la naturaleza no son taxativos, y una de las principales consecuencias que va a provocar la no taxatividad de los derechos de la naturaleza es el deber de no limitarnos a una estructura de catálogo cerrado o números cláusulos, sino más bien debiendo identificárselos en la manera de una forma de protección jurídica vinculada a la cláusula abierta.
The judgment addresses some interesting aspects, and the following are relevant paragraphs of the judgment in order to observe the analysis made by the court. First, the court notes the rights of nature. The court makes an important account of the jurisprudential advances made by that same body related to the rights of nature, emphasizing that nature is a complex subject that must be understood from a systemic perspective, and its components or particular manifestations may come to constitute specific right holders. The court warns that nature at all levels of ecological organization is protected by the law. Another important point that the court mentions is the principle of open clause. The opinion analyzes that the rights of nature are not taxative or exhaustive. And one of the main consequences of the non-taxativity of the rights of nature is the duty not to limit them to a closed catalog or numerous clauses structure, but rather to identify them in a form of an open clause of legal protection.
Hay otros aspectos más que considero de interés. La sentencia empieza a aproximarse a los derechos de los animales y va a señalar que dentro de los niveles de organización ecológica se va a reconocer que un animal es una unidad básica de organización ecológica y al ser un elemento de la naturaleza va a estar protegida por los derechos de la misma y va a gozar de un valor inherente individual. En ese punto, la sentencia va a conectar y va a empezar a desarrollar los animales como sujetos de derecho. Y de este modo, el reconocimiento de los animales como sujetos de derecho va a ser identificado como la fase más reciente en el desarrollo de su protección jurídica, la cual se va a sustentar en el reconocimiento de aquellos como seres vivos con una valoración intrínseca que los va a convertir en titulares de derecho.
The court starts to land in animal rights. The court states that within the levels of ecological organization, it is recognized that an animal is a basic unit of ecological organization. And because it is an element of nature, it is protected by the rights of nature and enjoys an inherent individual value. Also, the court mentions animals as subjects of rights. The court says that the recognition of animals as subjects of rights constitutes the most recent phase in the development of their legal protection, which is based on the recognition of the animals, as living beings with an intrinsic evaluation that makes them holders, subjects of rights.
De allí que la Corte va a reconocer que los animales y los humanos son sujetos diferentes. De esta forma, la Corte concuerda en que los animales no pueden equipararse a los seres humanos, puesto que su naturaleza y esencia no es plenamente compatible con la de aquellos, lo cual no significa que no sean sujetos de derechos. Y para esto, la Corte se va a sustentar en dos principios. Y aquí quiero acotar algo. Esos dos principios son importantísimos para esta sentencia, pero también son importantes para observar al derecho y su interrelación con otras ciencias y la necesidad de la interdisciplinariedad. Pero estos dos principios van a ser el principio interespecie, que va a configurar un principio mediante el cual se garantiza la protección de los animales, con un aterrizaje concreto en sus características, los procesos, ciclos vitales, estructuras, funciones y procesos evolutivos diferenciadores de cada especie.
The court, despite recognizing that animals are subjects of rights, states that animals cannot be equated to human beings, since their nature and essence is not fully compatible with that of the former, which does not mean that they are not subjects of rights. To address this point, the court analyzes two principles, two key principles in the decision, but also two principles that show the interrelation of the law with other sciences. These two principles are, first, the interspecies principle. The interspecies principle is a principle that guarantees the protection of animals with a concrete ground in the characteristic, processes, life cycles, structures, functions, and evolutionary process that differentiate each species.
El otro principio es el principio de interpretación ecológica. ¿Por qué es necesario que se tenga en cuenta un principio de interpretación ecológica que respete las interacciones biológicas que existen entre las especies, entre las poblaciones e individuos de cada especie? Como consecuencia, los derechos a la vida, a la integridad física y otros derechos deben de ser interpretados con base en estos principios, ya que las interacciones biológicas son el fundamento de la interdependencia, la interrelación y el equilibrio de los ecosistemas. Y esto último es de suma importancia, particularmente en lo que atañe a la relación de los seres humanos con otros animales, en la medida que hay un reconocimiento de que el ser humano es un depredador y al ser omnívoro por naturaleza, no puede prohibírsele su derecho a alimentarse de otros animales. Y aquí la sentencia aborda un aspecto también que considero que es relevante, que para mí son los aspectos más importantes de la sentencia, que es la procedencia de garantías jurisdiccionales. Para la tutela de los derechos de la naturaleza de forma general, pero para la tutela de los animales de forma especial, deberá evaluarse el objeto de una garantía y observar cuál garantía jurisdiccional se adecúa de forma más idónea al contexto y las pretensiones de las causas que se analicen.
The court also takes from science the principle of ecological interpretation. The court says that it is necessary to consider a principle of ecological interpretation that respects the biological interactions that exist between species and between populations and individuals of each species. As a consequence, the rights to life, to physical integrity, and others must be interpreted based on these principles, since biological interpretations are the foundation of the interdependence, interrelation, and equilibrium of ecosystem. And this is of huge concern, particularly with regard to the relationship of human beings with other animals. The court recognizes that human beings are predators, and because they are omnivorous by nature, they cannot be prohibited from feeding on other animals. And one key point, legal point that the court also addresses is that for the protection of rights of nature in general and of animals in particular, the court must evaluate which jurisdictional guarantee or constitutional claim best suits the context and the arguments of the case to be analyzed.
En el Ecuador ha existido un desarrollo jurisprudencial en los últimos años. Al inicio de esta charla, yo mencioné que esta sentencia hace un recuento de esa jurisprudencia que tiene el Ecuador, a la cual quiero referirme de manera muy breve, porque no es el objeto principal de lo que estamos compartiendo. La primera de esas sentencias es una sentencia del año 2021 llamada Río Akepi, donde la Corte va a desarrollar y examinar los derechos de la naturaleza, la protección del caudal ecológico, los parámetros de consulta ambiental y el derecho a la tutela judicial efectiva, en el contexto de una acción de protección planteada por comuneros habitantes de manera aledaña al río Akepi, cuerpo de agua cuyo caudal había sido autorizado para su aprovechamiento y que posteriormente fue declarado sujeto titular de derechos a la naturaleza.
As I mentioned previously, the court at the beginning of the decision makes a recount and narrates precedents related to the rights of nature. I will mention briefly some of these precedents because it is not the main objective of my presentation. The precedents that the court cites are, for instance, judgment number 1185-20 JP21 from the year 2021 that addresses an issue related to the Acuepi River. The court develops and examines the rights of nature, the protection of the ecological flow of the river, the parameters of environmental consultation, and the right to an effective judicial protection in the context of a constitutional claim brought by community members living adjacent to the Acuepi River, a body of water whose flow had been authorized for its use and which the court subsequently declared subject to and holder of rights of nature.
Luego quisiera señalar otras sentencias más. La siguiente es la 2167-21 EP del año 2022, una sentencia del río Monjas, que en su análisis la Corte va a declarar vulnerados los derechos a la naturaleza del río Monjas, los derechos a vivir en un ambiente sano y ecológicamente equilibrado, en conexión con el derecho al hábitat seguro, agua, desarrollo sostenible, ciudad, y al patrimonio cultural de los habitantes de la ciudad, y el derecho a vivir en un medio ambiente sano y ecológicamente equilibrado, en conexión con el derecho al hábitat seguro de quienes fueron los accionantes. Posteriormente a esto, hay otra sentencia, la 1149-19 JP21, Bosque Protector Los Cedros, donde la Corte Constitucional en la presente sentencia de revisión va a declarar la vulneración de los derechos de la naturaleza respecto del Bosque Protector Los Cedros y los derechos a un ambiente sano, derecho al agua y derecho a la consulta ambiental de las comunidades aledañas al bosque protector.
Two other important decisions is the decision related to Las Monjas River. In its analysis of the merits, the court declared the violation of the rights of nature of the Monjas River, but also the rights to live in a healthy and ecologically balanced environment in connection with the right to safe habitat, water, sustainable development, right to the city, and to cultural heritage of the inhabitants of the city, and the right to live in a healthy and ecologically balanced environment. Another decision is the decision related to El Bosque Protector Los Cedros, a natural forest. The court declared the violation of the rights of nature with respect to that forest, and also the right to a healthy environment, the right to water, the right to environmental consultation of the communities surrounding that forest.
Bien, y finalmente la sentencia 2218 IN21, conocida como sentencia de Manglares, en donde la Corte Constitucional va a aceptar una acción de inconstitucionalidad de algunos artículos del Código Orgánico del Ambiente y su reglamento, reconociendo la titularidad de los derechos de la naturaleza para los ecosistemas del manglar y declarando que un artículo del Código Orgánico de Ambiente no era aplicable para un derecho de consulta previa, libre e informada a comunidades, comunas, pueblos y nacionalidades indígenas. Estas son las sentencias de que brevemente me he querido referir para concluir con esta charla, no sin antes agradecerles enormemente por escucharme, por la invitación y por el tiempo que nos han dedicado a esta exposición.
Finally, we have decision number 22/18/IN/21. In that case, referred as the Mangrove case, the Constitutional Court partially accepts the public action of unconstitutionality, a claim to declare a law as unconstitutional with respect to several articles of the Ecuadorian Environmental Code and other regulations, recognizing the ownership of rights, recognizing that mangrove ecosystems are subjects of rights of nature, and declaring that Article 184 of that same environmental statute is not applicable for the right to prior, free, and informed consultation of communities and indigenous peoples and nationalities. I really appreciate the invitation for this webinar. I am really glad to be here with you, and I give the word to the next speaker. Thanks so much.
Thank you so much, Fernando. Thank you, Judge Nuquez. And now Hugo, I believe, has some slides as well. So I don't know if we need to do any, have we done our technical thing already? Good to go?
Thank you very much, Kevin. First of all, I would like to make sure that the volume is okay now. Okay, good to go. Well, first of all, I would like to thank George Washington Law, as well as the Earth Law Center for the invitation. It is an honor for me to join this panel with Honorable Judge Teresa Nuquez of the Constitutional Court of Ecuador. I will now share the screen with a presentation. Please confirm if you can see it.
Yep.
Okay, so we are ready to go. As you can see in the title, I would like to share with you this idea of the Estrellita case as a case very important because it actually built bridges between the rights of nature and animal rights. So this is the title of the presentation and the main point I will propose for this conversation. I will address the constitutional background. I will then emphasize on the scope of the Estrellita case. Again, and I will move to make the argument in favor of the concept of intrinsic value as the tool to build these bridges between the rights of nature and animal rights. I will address two principles. One of them has already been assessed by Judge Nuquez, to conclude with what Estrellita case says about the rights and duties regarding animal rights. As you all know, in 2008, the Constitution of Ecuador recognized rights to nature as a new subject of rights, as a new rights holder. As Judge Nuquez has already said, in 2022, is 2 years ago, the court decided on the Estrellita case, which is the last of 4 very important cases decided by the court between 2020 and 2022, specifically addressing the content as well as the scope of the rights of nature. This idea is very important because we have a constitution recognizing rights to nature back in 2008. And the court, we don't have any laws on the rights of nature. So the development of the content on these new constitutional rights is actually 100% jurisprudence. And there was a waiting time of over a decade in order for Ecuador to say to the world what is the content of these new constitutional rights of nature. Another idea that I want to share with you as a background, very important for you to know, is that the Constitutional Court of Ecuador is the highest authority on constitutional interpretation. So what the court says in its decision, it's very important. It's binding jurisprudence. And the Estrellita judgment, I agree, is you can see it as, or one can see it as the synthesis of the content and specifically on the scope of the rights of nature. If you take a look of the first part of the verdict, you will find a bit of history on what the court has said about the content of the rights of nature. And basically what you see in the jurisprudence in Ecuador is that the rights of nature are different than environmental rights, are autonomous. not only because the right holder is different, but also because if you want to put it into one word, the rights of nature are more strict than environmental rights. The standards set by the rights of nature are actually more protective to nature than the ones that one might find in environmental laws. We can address this specific topic in the question and answer period, but this idea is important to set from the very beginning. Taking all this in consideration, in 2022, the Constitutional Court recognized that animals are subjects of rights protected under the rights of nature. So you can see that the court expanded, this word is important, expanded the scope of the rights of nature as stated in the Constitution to also cover within the rights of nature the issues regarding animals' rights. Of course, this expansion was not free of controversy and debate. And by the time the court ruled on the Estrellita case, the leading approach was, on the one hand, was on welfare, a basic notion within the realm of animal law. And in the realm of the rights of nature, the leading approach was that the interpretation was that nature is a place, as the Constitution states, where life takes place. So you can see in the jurisprudence of the court, prior jurisprudence of the court, cases would concern with ecosystems like the mangroves, or with the river Akepi and river Monjas, and with Los Cedros forest. So all about places. And this you can find in jurisprudence, but also in doctrine. Basically, all academics in Ecuador will agree, before the Estrellita decision, will agree that nature, rights of nature belongs to a place. However, since 2008, there were other approaches, minority approaches, one might say, coming from a specialist on animal law. And they will always say that the rights of nature should expand to the elements of nature. This notion that was included in the debate by animal law scholars then began to be addressed by rights of nature scholars, or people working in the rights of nature, like me, like myself.
Maybe just while I have a second here, just to avoid the dead silence, I will give a quick update on, I mentioned habeas corpus cases. We've been talking about habeas corpus cases just before Hugo hopefully can get back in. Just to give an update. So of course, attempts to sort of have courts recognize the rights of non-human animals in the United States with habeas corpus so far have, you might say, not been successful, right? No court so far has granted the habeas corpus right, or really any other right. However, there's a very, say, healthy discussion going on among jurists and academics and others. And so there was a prominent decision in New York and a case involving an elephant named Happy. I was, honored to work on that case myself personally. Subsequent to that, I should say, that case went to the highest court in New York, the highest state court, where the court ultimately decided that Happy is not entitled to these rights because she is a non-human animal. And going back to something Hugo was talking about briefly, this idea of rights and duties, really so far in US law, broadly speaking, they really are tied together. That's been the sort of leading reason why non-human animals do not get rights under US laws, because they are not capable of taking on duties or responsibilities essentially the argument is around the social contract. So one thing I'm really interested to hear the contrast between different ideas of social contract, right? Every country has really their own, and that's typically often embodied in the Constitution and other documents. But, you know, in a lot of ways, we draw from some of the same ideas, which is what makes this exercise, I think, useful, right? When you really get down to, we're talking about rights and responsibilities and duties and who gets to have them. So it's very interesting to me to see how differently, and I know this shouldn't be a surprise, right? Courts in Ecuador, courts in the United States are obviously different culture, different everything, or different lots of things, but yet such a divergent, interpretation of what our legal system owes to other species, if anything. Of course, we have welfare laws, and that's brought up by the American courts. I should say also similar attempts have been made in California, in Colorado. There's a case ongoing in Hawaii. There may be additional states where the Non-Human Rights Project and perhaps other groups are, continuing this approach. But I think, the really important thing, no matter what the kind of legal vehicle is, that judges are now talking about this in a serious way. And I mentioned the New York case. I think one of the things certainly I'm most proud of from that, unfortunately, didn't win, and the elephant happy remains in this zoo in the Bronx, which is not great. But two judges of that New York's highest court, including one judge who's now the chief judge of that court, wrote very extensive dissenting opinions to explain why. When I see Hugo just pop back in, that's good timing. So Hugo, if you're ready to take over, I was just waiting for you to hopefully get back in. But yeah, I should say, those dissenting opinions really do hit a lot of the same notes that the Estrellita opinion touched on. So, all that to say, while it remains challenging, there's been some good progress. And I think Hugo's back. You might not have the slides, but I think we've got you. So I will hand it back.
Can you hear me? Okay. Well, the power just went out where I am right now. So I am connecting from my telephone. I just want to make sure that you can hear me and that you can see me.
Yep.
Okay. All right.
And Hugo, if you want, Claudia can put your slides up, if that would be helpful.
Yes, please. We
Okay.
are on slide number 5.
Okay, we'll get that up.
There. Thank you very much, Claudia. Okay, we can continue. Apologies for this interruption. I don't know what happened with the power, went down. I was saying that there were other approaches led by animal law experts that began by 2019 began to be addressed by rights of nature experts. And these approaches looked at the elements of nature, not only nature as a whole, but also the elements. Next slide, please. What you see there is a note, a note written in a blog of Lewis and Clark, in which by 2021, some lawyers, including myself, actually argued that the rights of nature should include animal rights, because Article 71 of the Constitution refers to protection of all elements of nature. Next slide, please. And here we come to the 2022 decision. This is what you see is a synthesis of paragraphs of the Estrellita decision. You can find in the number of paragraphs. What it is important is that the court concludes that the bridge between rights of nature and animal rights is this concept of intrinsic value. The concept of intrinsic value, as you know, is a concept, is not a new concept. You can find it in the 1982 UN World Charter for Nature. And the Constitutional Court has long stated that the intrinsic value is the foundation of the rights of nature. And the court takes this idea and expands it to the realm of animal rights. And the court concludes that these two fields share a common axiological foundation on the intrinsic value. And therefore, the court in the decision concludes that animals are subjects of rights protected under the rights of nature as guaranteed by Article 71 of the Constitution. So the intrinsic value is a very important concept that the Constitutional Court of Ecuador used as a foundation, as a foundation for to build this bridge between the rights of nature and animal rights. Next, please. Judge Núñez referred to several principles that the court developed in the Estrellita decision, and I would like to focus on this principle of ecological development. That, to me, is the most important contribution of the decision in terms of principles. Ecological development goes beyond the traditional concept of sustainable development, or the traditional, not traditional, but the current principle of sustainable development. In paragraph 60, you can see the definition of this principle, basically saying that the elements of nature are not to be used only on behalf of human interests, but taking into consideration the intrinsic value of nature. This is something that the Constitutional Court has already stated in earlier cases, but the important the contribution of this decision, of the Estrellita decision, is that the court put this notion into the level of a principle, of a new principle of the rights of nature. Remember, one has to remember that the rights of nature is an emerging trend. It's a theory that is under construction. So this principle of ecological development is very, very important for the development of this new theory on the rights of nature. Next, please. The ecological interpretation principle has already been explained by Judge Núñez, so I just want to emphasize that the court sends this message, important message, that in ecological interpretation, whenever interpreting laws in Ecuador, it means to respect the biological interactions existing between species and their populations, as well as individuals. Next, please. The court, you have to remember that this is a case about a wild animal, a woolly monkey. So the court focuses or emphasizes the issue of wild animals. It does not exclude domestic animals, but it certainly focuses on wild animals. And what the court says is that under the rights of nature, wild animals have the right to exist, and people or human beings have the duty to avoid wild animals to become extinct. This notion of rights and duties is very important because actually Article 73 of the Constitution of Ecuador sets the state duty to prevent extinction. I guess this is the only constitution to date in the world that includes a provision providing for the state to the duty to prevent extinction of wild fauna. So you see the court based its reasoning in this provision, and using that provision, it recognized the rights of wild animals to exist. something that, as we will see in a minute, is very important for practical application. Next, please. I am a lawyer, I am a practicing lawyer, so I always like to take a look of these decisions in order to see how they will apply in practice. So I want to share very briefly, considering the time, the case of sharks in Ecuador. Ecuador is a party of the CITES Convention since 1975. Ecuador was actually one of the first countries signing this very important convention, CITES. 50 years later, nearly 50 years later, last month, CITES, and this is very serious, CITES suspended trade of sharks from Ecuador. As of now, Ecuador cannot export sharks and rays because CITES concluded that Ecuador was conducting unsustainable trade. Basically because Ecuador has failed to set bycatch limits. I don't know, I don't see I'm just watching the presentation, so I don't know if I set the case or the problem is clear, or I need to add additional elements. Kevin?
Yeah, maybe just briefly and touch on, how some of the ideas we're talking about might come into play or.
Okay, so I just wanted to set the problem for you. Right now, Ecuador cannot, is prevented from trade under CITES because of unsustainable practices determined by CITES. Ecuador has failed, I insist on this idea, to set quotas on exports coming from bycatch, from accidentally taken sharks. Next, please. This is just the number of the notification if anyone wants to see. It's application of Article 13 of CITES in Ecuador. Next. Well, we have the problem. What is the solution? What CITES is requiring now is for Ecuador to regulate on quotas, on how many sharks could be exported, considering that in order to prevent their extinction. Okay, so CITES requires Ecuador to determine bycatch limits and to establish trade quotas for sharks and rays that we don't have now. Now, Ecuador has immediately begun addressing this problem, but the application that I want to share with you, and this is news because this will happen in the coming weeks. What the Fisheries Authority has to do is to set these quotas not only from a fisheries law perspective, not only from a wildlife law perspective that we have like any other countries, but also, and this is very important, this is the novelty, they will have to take into consideration animal rights standards as stated in the Estrellita decision. Specifically, they will have to regulate such quotas, taking into consideration the principle of ecological development. This is something very important because Ecuador is the only country in the world that includes animal rights standards in the discussion of wildlife. And sharks in Ecuador are marine protected fauna. Therefore, the standards set by the Constitutional Court in the Estrellita case literally apply to this regulation on shark quotas. Let's not forget that the Estrellita judgment has an erga omnes effect, is binding jurisprudence, and therefore the Fisheries Authority has to include these standards and this principle into their decision making. Next, please. To conclude, first of all, I would like to emphasize on the importance of the intrinsic value as the means to build a bridge between the new rights of nature and animal law. This is very important for the future of, in the way that animal law will be developed in Ecuador. It will be hand in hand with the rights of nature. Secondly, I applaud the decision of the court because it actually made a correct interpretation of the Constitution. Animals are part of nature, and therefore the rights of nature should be extended to their elements. The future, very briefly, another very important consequence of this case is that right now Ecuador is debating on a new bill on animal rights. This is a direct consequence of the Estrellita case. And secondly, as you can see, this case is going to make the difference for the protection of sharks. The principle of ecological development is going to be a player when regulating quotas on bycatch regarding shark trade. And finally, please, the final slide. You have there my email. Again, my apologies. The power went out in the area where I am right now, and there's nothing else to do. But luckily, I was able to connect by phone, and therefore, let's hope that the presentation was useful to you.
So much, Hugo. Glad we made it through, even with technical difficulties. Those happen all the time, so no worries at all. So I have a couple of questions. I've seen some questions coming in. Please keep those coming. I'll try to, kind of integrate them in a few minutes. We've got about 20 minutes, which is great. So I have a couple questions I just prepared and, have been thinking about listening to the remarks today. So I wanted to ask Judge Nuquez first, kind of set a little bit of the contrast here in the US. Rights of nature has been, considered by legislation by many states, or I should say a growing number of states. On the pro-rights of nature side, I think probably in my mind, at least the most prominent example, and maybe just because I'm in New York, but I think it's also been kind of the most sort of talked about, even though if it didn't really get that far. A legislator in New York State a year or 2 years ago or so proposed a bill that would have recognized the Great Lakes within New York State and connected ecosystems as possessing rights of nature. So I was obviously very excited when I saw that. Like I said, I don't think we've been tracking it, but I think it's kind of run into some legislative stuff. However, there also are a number of US states, including Florida, Utah, Idaho, possibly others, that have actually passed laws that ban nature from having rights. Some of them also explicitly say that animals cannot have rights. Some of them bizarrely to me anyway, say inanimate objects cannot have rights, which I'm not. There was even a question if that might invalidate their corporate laws, because of course, us lawyers know that corporations are persons and have rights, even if they are arguably inanimate objects, but that's a whole other thing. They also ban artificial intelligence from having rights, which is a whole different discussion, but some of them, at least Idaho, have lumped all of those things together and said, none of this, we're not going to have any of this. So my question really, with all that kind of background for Judge Nuquez, is kind of a difficult one, but if anyone can handle it, a judge can handle this kind of difficult question. How do we, as we try to learn, in Ecuador's experience, if you can speak to maybe some of the political backlash, or, for example, mining companies I've heard have become increasingly sort of organized against rights of nature. And so for other jurisdictions like ours trying to learn lessons, how can, in your opinion, the judicial system, but also society, continue to evolve together towards something like ecological development, and they do it in a way that doesn't, I suppose, cause too much political or social upheaval.
Doctora, su respuesta a la primera pregunta.
Bien, yo creo que el caso de Estrellita ha provocado diversas repercusiones en algunas o efectos a lo largo del Estado, que yo quisiera enfocarlos en tres aspectos que considero que son importantes, ¿verdad? El primero de ellos quizás es que a raíz de esta sentencia, una comisión de la Asamblea llamada eh, Comisión de Biodiversidad y Recursos Naturales en la Asamblea, y creo que de esa manera puede haber una contribución, ¿verdad? Empieza a trabajar en el proyecto de ley orgánica para la promoción, protección y defensa de los derechos de los animales no humanos. Y eso es un proyecto que está en debate y aprobación. Creo que eso desde la mirada de una función legislativa del Estado va a ir incluyendo aspectos en el ordenamiento jurídico del Ecuador. Yo creo que esa es una influencia importante en repercusiones que puede tener en la sociedad. Y porque en el proyecto, hasta donde yo lo fui observando en su momento, que no podría dar yo una respuesta actualizada al día de hoy, incluía esta idea de los principios interespecie y de interpretación ecológica, así como un principio conocido como indubio pro natura. Pero creo que este desarrollo no solo se ha venido dando únicamente en la parte legislativa, o sea, creo que esa es una parte que obviamente ayuda en lo que se refiere a la sociedad, ¿verdad? Pero creo que también la función judicial ha tenido un trabajo que pudiese ser interesante remarcar, porque ha empezado a tramitar acciones para defender la vida silvestre, ¿verdad? Y yo quisiera citar como ejemplo un caso de noviembre del año pasado, cuando una unidad judicial en Guayaquil, una ciudad aquí en el Ecuador, aceptó una acción de habeas corpus en favor de animales silvestres que se encontraban en un zoológico luego de advertir que estos se encontraban desnutridos y en condiciones precarias de encierro. Fernando, discúlpame que no te he dado tiempo de la traducción, pero porque no sé si ahí paramos un ratito para que tú puedas.
Sure. Sí, doctora. Well, Judge Nucas was talking about some political reactions, some political backlash, well, consequences, political consequences of the decision. First, there has been reactions in the legislative body of Ecuador. So, for instance, the National Assembly of Ecuador, which is the Congress of Ecuador, has a commission of biodiversity and national resources. And in consequence of the Estrellita decision, they have drafted a project of an organic statute for the promotion, protection, and defense of the rights of non-human animals. So this is a project for the enactment of the law. It's being debated in Congress, in the National Assembly, and Judge Nucas was telling that the last time she checked she reviewed the content of the project of the statute, this statute contained some important provisions. For instance, the interspecies principle, the ecological interpretation principle, both touched in the decision, and also the principle of indubia pro natura, which means that in case of doubts about the interpretation of an environmental statute, the interpretation that favors the most the environment and protection must be adopted by the court. Now, that on the legislative field, but in the judicial system, there has also been consequences. For instance, in November of the last year, a judge in Guayaquil accepted a habeas corpus in favor of wild animals that were in a zoo, after noticing that they were malnourished and in precarious conditions, in bad conditions. So these are two of the two branches of the government that have reacted Doctora, si pudiera continuar con su punto de esta pregunta.
Sí, solo quisiera agregar un aspecto más porque creo que son como pequeños pasos que va dando la sociedad, pero también el Estado desde los distintos poderes, ¿verdad? Y finalmente quisiera tocar el Poder Ejecutivo, ¿verdad? Porque se ha conocido que la Dirección de Biodiversidad del Ministerio de Ambiente, Agua y Transición Ecológica, con el apoyo de la Sociedad de Conservación de Vida Silvestre, ha organizado unos espacios de discusión con representantes de instituciones públicas, pero también privadas, con el fin de socializar y validar las propuestas de un protocolo para la protección de animales silvestres en procesos de retención y las normas técnicas para establecer condiciones mínimas que deben de cumplir los tenedores y cuidadores de animales silvestres como medios de conservación, manejo ex situ en el país. Eso quería complementar.
Yes, so finally, we touched the legislative branch, the judicial branch, but also the executive branch has reacted and moved towards the protection of right of nature. So for instance, an agency of the government called the Biodiversity Directorate of the Ministry of Environment, Water, Ministry of Environment, Water, and Ecological Transition, with the support of the Wildlife Conservation Society, has organized discussion spaces with representatives of public institutions and private entities in order to socialize and validate a protocol. This is an action of the government, and it's a proposal for the protection of wild animals that are in retention and seizure process, and technical standards to establish minimum conditions that must be met by holders and caretakers of wild animals. So for instance, how to conserve the animals, how to manage ex situ management in the country of Ecuador. Doctora, si quiere concluir la pregunta 1, no sé.
No, yo quisiera nada más hacer como un a modo de cierre. Yo creo que esto demuestra que la sociedad puede ir trabajando poco a poco, ¿verdad? Y puede ir trabajando poco a poco, lo puede hacer desde los distintos estamentos que tiene el Estado, puede haber una colaboración público-privada para ir estableciendo o ir discutiendo ciertos temas, porque creo que lo que hizo Estrellita fue dar un primer paso que es importante. Nosotros nos pensamos mucho la sentencia y la trabajamos durante casi un año, ¿verdad? Precisamente para crear un espacio de aceptación, pero obviamente es un primer espacio, porque quizás eso es lo más importante de la sentencia. La sentencia trató de entrar, avanzar, pero no ser totalmente agresivos en la sociedad para que la sociedad pueda recibirlo bien y el Estado tenga órdenes concretas hacia dónde trabajar. Y de ahí poder empezar a desarrollar poco a poco, ir desarrollando poco a poco. Por eso es que yo siempre digo, esta sentencia fue una sentencia de muchísimo trabajo, pero de muchísimo, de pensar mucho, cómo iba a ser recibida y cómo iba a permitir empezar a dar pasos más adelante.
Well, finally, George Lucas mentions that this is a process that, takes step by step. There must be a coordinated work by society and the branches of the government. She mentions that she worked for over 1 year in the decision, carefully reviewing every detail of the decision, and that the court intended for this decision to be a first step, an introduction, an entry to the development of rights of nature. There was a lot of work, a lot of legal analysis, but also there was a careful consideration of the impacts of society that this decision would have. The court decided not to be abrupt, not to, break society, but to be careful in introducing this topic. That's the answer of the judge for question number 1.
That's great. Thank you so much. And I have one question for Hugo, and then I see some here, so I'd love to try to get in some audience questions as well in the time we have left. So Hugo, I know you've been in the trenches doing these cases for a long time and have seen, I'm sure, the way that your experience in court, I'm sure, has changed, and your experience with other lawyers. You mentioned how in recent years, the opposition has become maybe more sophisticated, right? They have maybe better lawyers on the other side. And maybe somewhat surprising to people, you've said that you think that actually helps. I'd love to hear you talk a little bit more about that process and what you've seen and how things have maybe changed over your career making these kind of arguments.
Thank you. I'm back on my main screen. Can you hear me? Okay. Well, okay. In order to answer to your question, please, it's important to understand that the rights of nature are different from environmental rights. Environmental rights are human rights. The rights of nature are the rights of nature. And if one in a word, the rights of nature are better than environmental rights, are better, protect nature better than environmental rights. That's basically the main conclusion when you read the jurisprudence of the Constitutional Court. That is the main juridical conclusion. Secondly, the rights of nature have been addressed at a constitutional law level, and this is very important, and please follow me with this. Whereas environmental rights or environmental law has belonged mainly to administrative law, the rights of nature from the very beginning began to be addressed as a constitutional right. Okay, so if one reads the decisions of the court, when the court addresses rights of nature, they are addressing basic constitutional principles and rules, such as the legal reserve principle, such as the issue of direct application, and our legal security. What I'm trying, and having said this, and knowing and learning that the rights of nature are really strong when protecting nature, one has begun to see a reaction from those who have been affected by the decisions of the court in the rights of nature. Let's take an example. There have been projects, destructive projects, mining projects, to mention one case, not the only one, but one case, or hydropower plant projects that have gotten the authorization of the state, okay? Because those projects complied with environmental regulations. Nevertheless, these projects did not comply with the constitutional standards on the rights of nature. Okay, that is that is what is happening in Ecuador. So you are now seeing and witnessing a reaction from those sectors that have been affected by these decisions. And what you see is that the level of the reaction is they have very good lawyers, the very best of the country, and in my opinion, and they present very good arguments for the court. So what you have now is a debate between arguments in favor of the rights of nature and arguments against the rights of nature, but the best of the arguments. And in my opinion, that will the effect of that is that the future decisions that the court will adopt will be adopted in the context of the best of the legal controversy that the country may offer. And the outcome of that will be that whatever the development of the rights of nature and animal rights as well will ensure a very high level of legal knowledge. So you see, in my opinion, I am very happy to see the best constitutional law professors, scholars, attorneys addressing these topics. In most cases, against the rights of nature, in other cases, in favor, because that debate will create a very good outcome on doctrine, on theory on the rights of nature.
Awesome, thank you. So I think we have a couple minutes here. I'm just looking through some of our questions. So maybe for Judge Nuquez, quickly, tying some of these ideas together and knowing that you have many cases in front of you and you maybe can't be too specific if it's about a particular case, but thinking about different parts of going from Hugo's comment about rights of nature used to really be thought of as about just a place. How is science and increasing knowledge of really the fact that even a place is really just a collection of so many different organisms? How is the court trying to tie all that together, looking into the future as you continue to develop rights of nature? Will it continue really in the court, or do you see it kind of going into more of the legislative realm, kind of like what's happening with the animal rights bill?
Sure. Okay, so la pregunta básicamente es si usted cree que el desarrollo de la Corte pues va a seguir siendo predominante, en especial con los aspectos de ciencia, o si este campo pues va a pasar un poco más a el lado legislativo y va a estar más en manos de los legisladores y del Congreso como tal.
Bien, yo creo varias cosas. La primera de ellas, el rol jurisprudencial o el rol que tiene la jurisprudencia dentro del ordenamiento jurídico del Ecuador es un rol importante. La Corte es una Corte que tiene una jurisprudencia vinculante y que ha trabajado de manera importante en los últimos años en su línea de trabajo en el desarrollo de los derechos de la naturaleza, amparado en la norma constitucional y en la correcta interpretación de la norma constitucional. Obviamente, esto va generándose a raíz de los casos en que la Corte empieza a trabajar. Si bien hay temas que a medida que va resolviendo o atendiendo situaciones que se presentan en los casos, va observando la normativa constitucional existente y dentro de sus competencias va pronunciándose jurisprudencialmente, también en casos concretos va observando y trabajando en lo que necesita el ordenamiento jurídico. Y a veces eso hace que la Corte establezca ciertas directrices hacia la Asamblea, porque también hay temas que son importantes que deben de ser tenidos en cuenta, ¿verdad? El desarrollo del derecho ahora obedece a a fuentes múltiples, la jurisprudencia dentro del campo de competencia de las Cortes y también los órganos legislativos que tienen la facultad de regular predominantemente. Creo que el caso Estrellita es un ejemplo de ello, porque en este caso la Corte hace una interpretación de los artículos 71 y 73 de la Constitución, que creo que es una base muy importante, pero también la Corte se dirige al órgano legislativo y le dice, órgano legislativo, ustedes tienen un plazo para abordar este tema y desarrollarlo, ¿verdad? Y da los parámetros de desarrollo a raíz de su facultad interpretativa. Y también se dirige hacia quienes tienen la ejecución muchas veces de políticas públicas o el llevar a cabo manuales o reglamentos que son necesarios para la aplicación de ciertas acciones y establece estos parámetros. Creo que es un trabajo conjunto definitivamente de un Estado que se puede manifestar dentro de sus distintos órganos, así como de otros órganos, como la Corte, que no es parte de los órganos del Estado, pero perdón, me refiero a que no es un órgano que está dentro de las funciones del Estado, de las 5 funciones que tiene el Estado, pero que sin embargo tiene una facultad prevista constitucionalmente que le permite hacer este desarrollo.
Sure. Well, the answer of the judge is that the jurisprudential role of the court inside of Ecuador is important. The court obviously has the power to decide binding cases, binding precedents, and the court with the cases that have arrived to it, has developed the rights of nature. Now, obviously, this is limited to the cases that arrive to the court. But it is important to establish that the court has the power to direct the other branches of the government to address certain issues in order to save, to protect rights and conceptions of the Constitution, because we have to remember that these are constitutional provisions that grants the power the court to direct other branches of the government. So, for instance, Estrellita is a fundamental example, a clear example. In that decision, the court addresses and develops the rights of nature. But not only that, it also tells Congress to regulate this issue. It also gives guidelines to Congress on how to regulate this issue. And that is important. And we can see the predominant role of the court when developing rights and provisions of the Constitution, such as right of nature, in this specific case, Article 71 and 73 of the Constitution. Now, this can also, obviously, the decisions of the court and the guidelines of the court also can extend not only to Congress, but also to the executive branch, which directs the public policies of the government, and also to society.
Great, thank you so much.
Kevin, can I add just a 30-second comment on this?
Yeah, please do.
Okay. What Judge Nuques has said is very important, because the future of the rights of nature, including animal rights, has already been set by constitutional law standards. So the future of the rights of nature, at least in Ecuador, belongs to constitutional law. And that is very, very important, because if you take a look of what has happened with environmental law in Ecuador, is not necessarily the same way. Environmental law went closer to administrative law, whereas the rights of nature and now animal rights, thanks to the Estrellita verdict, has gone beyond to constitutional law.
Yeah, so obviously for us in the U.S. who are trying to do this work, it's very exciting, and just want to say thank you to everybody again for putting this together. And just going off one last question I saw. Do U.S. courts, are they really moved by this stuff? And I think the answer is mixed, but in general, definitely yes. And I think there's a sort of gravitational pull that happens as well when, countries really take this rigorous and serious approach to, like you said, elevating the rights of nature and animals with it to a constitutional question. And so really appreciate, both of you and your work and your time, and just want to say thank you, and thank you to everybody who joined, and thank you for staying a little bit late with us, and I hope to see you all again soon.